We're on the record in 3 cases. The first case is cause number 328912. The second case is cause number 325272. And the third case is cause number 327834. All 3 cases are styled the state of Texas versus Henry Charles Pressler IV. Mr. Pressler, would you please raise your right hand? Mr. Pressler, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Okay, Mr. Pressler, you may put your hand down. How you do? Okay, Mr. Pressler, let's see. Earlier, Mr. Pressler, the court read to you the judge's explanation of rights to defendants without an attorney, and you informed the court that you wanted to waive your right to an attorney and to represent yourself. Is that correct?
That is correct.
And after reading you the right to, after you stated that you wanted to waive your right to an attorney to represent yourself, the court read to you the waiver of your right to be represented by an attorney that is included in State's Exhibit number 1 under the paragraph called, that's titled waiver. Is that correct?
That is correct. That is correct, Your Honor.
Now, Mr. Pressler,
Yes, Your Honor.
I have before me in cause number 325272, a first amended motion to revoke your probation. In this motion, Mr. Pressler, the state alleges that on January 10th of 2020, that you were found guilty for the Class B misdemeanor offense of criminal mischief, and your punishment was assessed at 90 days confinement, Jefferson County Jail, with no fine, and your confinement was probated for a period of 1 year. On March 30th of 2021, the state filed its first amended motion to revoke probation. In this motion,
Hold on. I believe that my maximum punishment is 120 days.
Actually,
I believe that I'm under the impression that
no, hold on, Mr. Preston, just let me read to you what's in the motion. The motion states that your punishment was assessed at 90 days confinement in the Jefferson County Jail with a no fine plus court costs, and that jail time or that confinement was probated for 1 year.
Oh, jail time. Okay, probation for 1 year. 90 days probated over 1 year, correct?
That's right. Just
Okay, I got it backwards whenever I understood it backwards, but now I understand.
All right. Now, in this motion, there are 7 allegations. State, are you abandoning any of the allegations?
Yes, Your Honor. The state is abandoning allegations 1, 4, 5, and 6. We're only proceeding on allegations 2, 3, and 7.
Okay. Now, Mr. Pressler, the state,
Yes, sir.
the state is abandoning allegation 1, 4, 5, and 6, and they are only proceeding on allegations 2, 3, and 7. And I will read to you each allegation. Allegation 2 alleges that you failed to report to the Jefferson County Probation Office as ordered by the court for the months of September and October of 2020 as directed in violation of condition 4 of your probation order. Is that true or not true?
Yes, I missed my appointment date.
Okay, you have to say true or not, either
True.
Okay. And allegation 3 allege that you failed to pay court assessed fees as ordered by the court, and as of October 22nd, 2020, that you were $2,192 in arrears in violation of condition 8 of your probation order. Is that true or is it not true?
True.
Allegation 7 alleged that you failed to report to the Jefferson County Probation Office as ordered by the court on January 14th of 2021, February 25th of 2021, March 9th of 2021, as erected in violation of condition 4 of your probation order. Is that true or not true?
True.
Are you pleading true to allegation 3, 4?
I'm pleading true to all allegations that the state is accusing me of. Yes.
Okay, well, the state has abandoning, okay, so you're pleading true to allegation 2, 3, and 7. Is that correct?
Unless they're abandoning them, then no.
Okay,
Then yes. I mean,
listen to my question. The state is only proceeding on 3 of the allegations. Those allegations are allegation 2, allegation 3, and allegation 7. Those are the allegations that you pled true to.
yes, they're all true.
Okay.
All 3.
And are you pleading true to those allegations freely and voluntarily?
Freely and voluntarily and of sane and sound mind. Yes, Your Honor.
And are you pleading true to these allegations because they are true?
Because they are true and correct. Yes, Your Honor.
Okay. Now, Mr. Pressler,
Yes.
I have before me the misdemeanor plea admonishment. Oh, this is going in the back. The misdemeanor plea admonishment, which is State's Exhibit number 1. And on State's Exhibit, I was looking at the wrong one. Okay, on State's Exhibit number 1, Mr. Pressler, in cause number 325272, on the first page, the first box says check is MTRP, which means motion to revoke probation. On the second page, there are 2 sets of initials. One set of initials is on a line next to a box that says check MTRP, true to allegations 2, 3, and 7. And Mr. Pressler, are these your initials next to this box?
Yes, they are.
And below the paragraph that is titled Discovery Admonishment, the same initials are on a line that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea. In here it says guilty or no contest. I'm gonna change that to true because this is a motion to revoke probation and I will initiate it. Now, Mr. Pressler, do you understand the change that I've made?
Yes, I do.
And are these your initials on this document?
Yes, they are.
Now, Mr. Pressler, on page 3 of the same document, there's a signature above the line that says defendant. That purports to be your signature. Did you sign this document? Did you
Yes,
sign?
I did.
Okay. And on the next document, which is the trial court certification of defendant's right of appeal, there's a signature above the line that says defendant. Is that your signature?
Yes, Your Honor.
There's one box that's checked at the top of this document. That box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I do, Your Honor.
Okay. Now, Mr. Pressler,
Yes, sir.
prior to signing and initialing these documents, did you have an opportunity to read the documents?
Yes, I did, and I understand them fully.
Okay, so you read the documents and you understand everything that you read?
Yes, Your Honor, I do.
And is everything in these documents true and correct to the best of your knowledge?
To the best of my knowledge, they're true and correct.
State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Mr. Pressler, I have before me State's Exhibit number 1. State's Exhibit number 1 is the document that have your initials on page 2 and your signature on page 3. The state would like to use this document as evidence against you in this case. Is it all right for the state to use this document as evidence against you in this case?
Yes.
No objection. State's exhibit number 1 will be admitted. Mr. Pressler,
Yes,
Is
Your Honor.
is there any evidence that you're currently mentally incompetent to stand trial?
Not at this moment, no, sir.
Okay, Mr. Pressler, I will accept your plea of truth to allegations 2, 3, and 7. I will also find that you are mentally competent to stand trial, and I will also find that your pleas and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. For this case, the agreement is 90 days county jail, and that's to run concurrent with cause number 327-834 and cause number 328-912.
Okay, Mr. Pressler, the state is offering that you serve 90 days in the Jefferson County Jail, and you will be given credit for any time that you're entitled to get by law. The court cost in this case is $67. Mr. Pressler, would you be able to pay the court cost of $67 in this case?
Today?
Before you get out?
I'm not able to pay anything at all right now because I'm incarcerated.
Okay, that's what I need to know. I just have a few questions to ask. So, Mr. Pressler, currently you're unemployed, is that correct?
Currently, yes, Your Honor.
And now, Mr. Pressler, do you receive child support?
No, I don't receive anything at this moment. I'm incarcerated, Your Honor.
Okay, so you don't get food stamps, no Social Security, or no other governmental checks, is that correct?
Not at this moment, Your Honor.
And you have no other source of income, is that correct?
I have $2 to my name.
Okay. Now, assets, do you own a home or do you own a car?
I did, not any longer, no.
Okay, okay, that's what I need to know. Now, you're not paying any rent, is that correct?
No, not at this time. Believe I'm currently homeless.
Okay, you're homeless? Okay, I needed to know that. Okay, no utility bills. Are you required to pay child support?
I'm not required at this moment.
Okay, now, you don't have a food expense, do you?
I'm in the county jail. They
Okay.
provide my meals.
Okay, and transportation costs is $0. You don't have a cell phone or anything, and you're not currently required to pay any probation fees, right?
No, I believe I've revoked the probation. I can't pay anything, Your Honor.
Okay. Now,
I'm not working right now.
and you don't have any medical expenses, right?
I have a surgery that I need on a hernia, but I'm
Okay,
incarcerated, and I don't know if they're gonna pay for it or not. I don't know.
okay, so Mr. Pressler, the court is going to find that you are indigent, which means that the court cost in your case is going to be waived, which means you won't have to pay it.
This is on the criminal mischief case on the NTRP. Yes, Your Honor.
Okay, we're doing one case at a time.
Yes, I'm just stating that that's the same thing we're talking about.
The same case we're talking about, right? When I
Yes,
told you that the court cost was $67,
yes. And the restitution was 2,000 or something?
well, in this particular case, Mr. Pressler, the state's offer was 90 days, and the court cost will be waived because the court have found that you are indigent. Do you understand the state's offer and the court's judgment?
Yes,
And do you think that it's fair and just?
yes,
And do you accept it?
I accept it.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Pressler, I have another case here. This case is cause number 327-834. And this case is also a motion to revoke your probation.
Can you give me a defense date? Like an offense date with the cause number, please? It'll help me understand better.
I'm gonna read everything that's on this motion.
Okay.
Okay, so, Mr. Pressler, I have before me a motion to revoke your probation in the second case, which is cause number 327-834.
Mm-hmm.
Hold on a minute. Is there an amended motion in this case?
On that second one?
Yes. Just the one?
No,
Okay.
Your Honor, just the one motion in this case.
Okay, thank you. Okay, Mr. Pressler. In this case, the motion to revoke probation states that on November 5th of 2020, that you were found guilty for the offense of trespass, and your punishment was assessed at 30 days confinement in the Jefferson County Jail without a fine, and the confinement was probated for a period of 1 year.
Yes, Your Honor.
The state filed a motion to revoke your probation on March 30th of 2021. In this motion, there are 5 allegations. State, are you proceeding on all 5 of the allegations?
Yes, they're all true.
No, Your Honor, we're not proceeding on all 5. We're only proceeding on,
Is it 2 and 3?
yes, Your Honor, I'm sorry, I was trying to read it again. It's 2 and 3 that we're proceeding on, and we're abandoning 1, 4, and 5.
Okay. Now, Mr. Pressler, the state is abandoning counts 1, 4, and 5, and the state is proceeding on allegation 2 and 3. Allegation 2 alleges that you failed to report to the Jefferson County Probation Office as ordered by the court on January 14th of 2021, February 25th of 2021, March 9th of 2021, as directed in violation of condition 4 of your probation order. Is that true or not true?
Both allegations are true.
Okay, I have to read each one of them off, and then you have to answer true to each one.
Okay.
Allegation 3 alleged that you failed to perform community service hours required as ordered by the court in violation of condition 14 of your probation order. Is that true or not true?
True. I wasn't able to do community service.
Okay, so now are you pleading true to allegations 2 and 3 freely and voluntarily?
Yes.
And are you pleading true because they're true?
Yes.
Okay, now, Mr. Pressler, I have before me State's Exhibit Number 1. State's Exhibit Number 1 is the misdemeanor plea admonishment. On page 1, one box is checked stating that this is an MTRP, which means motion to revoke probation. On page 2 of this document, there are 2 sets of initials. The first set of initials is on a line next to a box that's checked MTRP, motion, which means motion to revoke probation, and it says true to allegations 2 and 3. And below there are a set of initials below the paragraph that says this discovery admonishment, and it is on a line that reads, I do not request discovery of the evidence. I waive my right to request the discovery of the evidence in this case and choose to enter a plea of guilty, no contest. I will make the corrections here from guilty and no contest to true, because this is a motion to revoke probation. Now, Mr. Pressler, do you understand the corrections that I'm making on this document?
Yes, I do.
Now, are these your initials on both sets of these lines?
Yes, Your Honor.
Now, on page 3 of this document, there's a signature above the line that says defendant. Is that your signature?
Yes, Your Honor.
And on the next document, which is the trial court certification of defendant's right of appeal, there's a signature above the line that says defendant. Is that your signature?
Yes, Your Honor.
There's one box that's checked. This box states that this is a plea bargain case and you have no right of appeal. Is that correct?
Yes, Your Honor.
And like in the previous case, you informed the court after being read your judge's explanation that you explained to the court or you stated to the court that you wanted to waive your right to an attorney to represent yourself, and you were read a waiver of counsel, and you acknowledged that that was your desire. Is that correct?
Excuse me?
The court read to you the waiver of counsel, and you acknowledged that that was your desire to waive counsel in this case, and you wanted to waive your right to an attorney and to represent yourself.
Yes.
Okay.
I heard something else. I'm sorry.
Now, Mr. Pressler, prior to signing and initialing these documents, did you have an opportunity to read these documents?
Yes, I did.
And did you read the documents?
Yes, I did.
And did you understand what you read?
Yes, I did.
And is everything in these documents true and correct to the best of your
Yes, Your
knowledge?
Honor.
State, I have before me State's Exhibit 1. State, you like to offer State's Exhibit number 1?
Yes, Your Honor.
Mr. Pressler, State is offering State's Exhibit number 1 in this document. That's the document that have your initials on page 2 and your signature on page 3. State would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence against you in this case?
Yes, Your Honor.
Okay, no objection. State's Exhibit number 1 will be admitted. And in this case, Mr. Pressler, is there any evidence that you're currently mentally incompetent to stand trial?
Not in this trial, Your Honor.
Okay, Mr. Pressler, the court is going to accept your pleas of truth to allegations 2 and 3. And the court is going to find that you are mentally competent to stand trial. The court is also going to find that your pleas and waivers were freely and voluntarily given. The state is also going to find that there is sufficient evidence to revoke your probation, and your probation is revoked in this case. And if I didn't mention, your probation was also revoked in the previous case. Now,
Yes.
Mr. Pressler, State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 30 days county jail, and that's to run concurrent with cause number 325-272 and 328-912.
Okay, Mr. Pressler, the state is offering that you serve 30 days in the Jefferson County Jail in this case, and you'll be given credit for any time that you're entitled to get by law. There's court costs of $107 to be paid in this case. And just ask the question, are you able to pay the $107?
No.
Okay, Mr. Pressler, the court found you indigent in the previous case. The court will also find you indigent in this case. And in this case, the $107 court cost is going to be waived. Mr. Pressler,
Yes, Your Honor.
do you understand the state's offer and the court's judgment?
Yes, and it's concurrent with the previous cause number. Yes, Your Honor.
Yes, we'll run concurrent with cause number 325-272 and cause number 328-918. And Mr. Pressler, do you think that the state's offer is fair and just?
Yes, and thank you, Your Honor.
And do you accept the state's offer?
Yes, I do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state, and your court costs will be waived in this case as well. Now, Mr. Pressler, we have another case before us. Well, the other case is 912. Okay. Mr. Pressler, we have another case before us. This case is cause number 328912, and it's styled the state of Texas versus Henry Charles Pressler IV. And in this case, there's an information that alleges that on or about February 16th of 2021, that you committed the class A misdemeanor offense of violation of a protective order. Mr. Pressler, do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, Mr. Pressler, how do you plead? Guilty, not guilty, or no contest?
I believe I plead no contest.
Yeah. And are you pleading no contest freely and voluntarily?
Yes, Your Honor.
Are you pleading no contest because you do not wish to fight or contest the charges?
I do not contest the charges, and I agreed with the state's offers to run concurrent with the previous cause numbers, and I agree.
Okay, now, Mr. Pressler, And are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
And Mr. Pressler, I have before me a document that is titled the misdemeanor plea admonishments. And on page 1, there's one box check stating that this is a class A misdemeanor with confinement in jail for term not to exceed 1 year, a fine not to exceed $4,000 or both such fine and confinement. That is the range of punishment for a class A misdemeanor. Do you understand that?
Yes, Your Honor.
And on page 2 of this document, Mr. Pressler,
Yes, Your Honor.
there are 2 sets of initials. One is on the line that says nolo contendere, which means no contest. The other set of initials is on the line below the paragraph that is titled discovery admonishment, and it is on a line that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest.
I enter a plea of no contest, Your Honor.
Okay, now, Mr. Pressler, are these your initials on this document?
Yes, and we're talking about the class B misdemeanor offense of trespassing, right?
No, we're talking about the violation of a protective order, class A misdemeanor.
Hey, yes, okay, I'm sorry. I just got a little confused. It's a lot. It's
Okay,
kind of hard to hear. Yes, and I understand.
okay. Now, Mr. Pressler, on page 3 of the same document, there is a signature above the line that says defendant. Is that your signature?
Yes, it is.
And on the next document, which is the trial court certification, the defendant's right of appeal, there's a signature above the line that says defendant. Is that also your signature?
Yes, Your Honor.
There's one box that's checked up here. This box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I understand the state's offer and I accept it, yes.
Okay, now, Mr. Pressler, prior to signing and initialing these documents, did you have the opportunity to read these documents as well?
Yes, Your Honor.
And did you read these documents?
Yes, Your Honor.
And did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
to the best of my knowledge, and I believe that everything in the NTRP and the Class A misdemeanor are all ranked concurrent with the previous cause numbers and the state's offer. I agree and accept.
Okay, with this case, the documents that you signed and initialed, are all of these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. Now, Mr. Pressler, in this case, is there any evidence that you're currently mentally incompetent to stand trial?
Not in this trial, Your Honor.
Okay, Mr. Pressler, I will accept your plea of no contest. I will find that you are mentally incompetent to stand trial. I also find that your plea of no contest and waivers were freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, but first, the state would like to offer State's Exhibits 1 and 2 in this case, and State's Exhibit 2 is the probable cause affidavit for this case.
Okay, Mr. Pressler, the state is offering State's Exhibit number 1 and 2 in this case to be used as evidence against you. State's Exhibit number 1 is the document that have your initials on page 2 and your signature on page 3. State's Exhibit number 2 is the probable cause affidavit, commonly referred to as the police report. Mr. Pressler, is it all right for the state to use these documents as evidence in your case?
Yes, Your Honor.
Okay, no objection. State's Exhibit number 1 and 2 are admitted. And
Your Honor, as for the plea agreement in this case, it's 120 days county jail, and that's run concurrent with cause number 325272 and 327834.
okay. And Mr. Pressler, the state is offering that you serve 120 days in the Jefferson County Jail. In this case, there is court costs that, the court cost in this case is $327. And again, I will ask you, will you be able to pay the $327?
No, Your Honor, I cannot.
Okay, so Mr. Pressler, as in the previous 2 cases, the court is going to find that you are indigent, and the court cost is going to be waived. So this case will also run concurrent with cause number 325-272 and cause number 327-834. Mr. Pressler, do you understand?
Those two previous cause numbers are my NTRPs, right?
Yes.
Okay, yes, I understand. I'm just kind of, when you read off numbers, it's kind of hard. That's why I said offense states are easier. But yes, I understand.
Okay, so we're gonna,
The
so now,
class A misdemeanor is ranked concurrent with the two previous NTRPs. I understand. And I
okay,
agree and accept.
and you also understand that your court cost in this case is going to be waived.
Yes, Your Honor.
And the sentence in this case that's running concurrent with the other cases is 120 days. Do you understand?
Yes, Your Honor.
Do you think that the state's offer is fair and just? Do you think that the state's offer is fair and just?
Yes, it is. Yes, Your Honor.
And do you accept the state's offer?
I do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Pressler, because this is a violation of protection order case, I have to read to you the written admonishment. And it states, in accordance with the Texas Administrative Code, section 176.1 of the court hereby admonish you of the following. You are by entry of order or judgment ineligible to, under Texas law, to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under the Texas Penal Code, section 46.01, subsection 3, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife, blade, or other characteristics of weapons made illegal by Penal Code 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons misdemeanor,
I reject that.
family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective orders. Now, Mr. Pressler.
Yes, I have a question, Your Honor.
Hold on, let me finish. Mr. Pressler, you will be given a copy of this ammunition by the bailiff once you leave out of this room, okay?
And section 4606, possession of a firearm by felon in the state of Texas after 7 years of conviction date, does that count on person's own property in which they own?
Okay, Mr. Pressler, I cannot give you any legal advice. you can consult and you should consult an attorney.
I may have to consult an attorney on this one. I do not accept it.
What do you not accept?
The fact that I do not understand 4606 and the violation of the possession of a firearm and the possession of ammunition. I understand that a person is not allowed to carry or possess that outside of their own property, but does that count on their own residence?
Okay.
I don't know that. That's
Okay.
that's one thing I don't know.
Okay.
And if it does count, like if it's on their own, if they carry it offside of their property.
Okay, Mr. Pressler, as I said, the court cannot give you any legal advice. For any legal advice, you should consult an attorney.
Can we recess for just about 30 seconds?
Hold on a minute.
And go off the record.
Hold on, Mr. Pressler, just call the bailiff. I have somebody else to come in.
Bailiff, I need what's the matter? Recess. I need a recess.
Kepo,
Hold on.
Kepo,
Yes, sir.
is that other guy there?
Yes, sir.
Okay, let me bring him in. He needed,
For Odom?
yeah, let me bring Odom in. Let me talk to Odom while he's out. He needed a break or something.
What's the matter with Mr. Pressler?
I have no idea. Just bring Mr. Odom in so I can give him his warning.
Okay, swap out. Come on. Something right here. Okay, good. Yes, sir. How you doing?
Mr. Odom. Okay, Mr. Odom. Okay, we're back on the record in cause number 328656. The case is styled the state of Texas versus Eugene Marvin Odom. Mr. Odom entered a plea earlier to the charge of protective order violation, and the court, as required by the Texas Administrative Code, section 176.1, is required to read Mr. Odom the model written admonition on ineligibility to possess a firearm or ammunition. Now, Mr. Odom, in accordance with the Texas Administrative Code, section 176.1, the court hereby admonish you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code, section 46.01, subsection 3, A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Order for Emergency Protection. Code of Criminal Procedure, Article 42.0131, notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearms. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking or trafficking case. Family Code Section 85.026, warnings on protective orders. Mr. Odom, the bailiff will give you a copy of this admonishment for your records. Mr. Odom, this will conclude your hearing. Mr. Odom, please have a blessed day and follow the bailiff.
Okay, you too. Thank you, sir.
Okay, you can knock on and tell the bailiff that you're ready.
Okay, thanks. I'm finished.
All right, I'm ready.
Okay, okay, we're back on the record. I think the last case that we had was number 328912. The case was styled as stated.
I can't hear with the door open.
Okay, could you close the door? Okay, now we're back on the record in cause number 328912. The case is styled the state of Texas versus Henry Charles Pressler IV. Okay, now, Mr. Pressler, the court has just read you the admonishment as required by the Texas Administrative Code, Section 176.1, and you will get a copy of this admonishment by the bailiff for your records. And this will.
Are we talking about the Class A misdemeanor offense of violation of a protection order?
Yes.
I do not agree with the state's offer. I would like to advise an attorney.
Okay, now let me ask you this here. Now, you want an attorney on all of your cases?
No.
Okay, so on the case, the violation of protective order, so the court is going to allow you to withdraw your plea on that case, and
I would like to skip and go to the next charge.
There's no other charge. You already did those two. That was your last charge. So what I'm hearing from you is that you're going to continue with the first two cases, your motion to revoke probation, but on your third case, the violation of a protective order, you're withdrawing your plea and you're requesting an attorney be appointed to represent you. Is that correct?
Yes, Your Honor.
Okay, so what we're going to do, you're going to have to fill out there's an affidavit out there that you'll have to fill out, and they'll get it to the court, and if you meet the eligibility requirements, then we'll appoint an attorney to represent you.
Yes, I just want to make sure I fully understand everything, and that was my only thing that I don't understand. Okay, but on the offense, I believe don't I have two more offenses?
No, you already pled true to those two motion to revoke probation.
Okay, in total, how many charges do I have? 2 MTRPs, 1 Class A misdemeanor, and 1 Class B trespassing.
No, that's it. The two, you pled true to the 2 motion to revoke probations, and then you have this 1 violation of a protective order that you are withdrawing your plea, and you are asking the court to appoint an attorney to represent you on. It's 3.
Yes, I don't quite ever understand everything that's involved.
Okay, when you say everything that's involved, are you talking about the 1 case or all the cases?
I'm talking about the Class A misdemeanor offense.
Okay.
Everything else I understand and I'm ready to plead to today.
Okay. So what we're going to do is the bailiff, follow the bailiff. The bailiff is going to, they'll get you the form that you need to fill out, and that form will get to the court, and the court will, once we review it, make the determination that you're eligible for the court-appointed attorney, which you probably are, because the questions that I've already asked were the same questions that's on the form.
Yes, Your Honor.
Okay, all right, so, Mr. Pressler, just, knock on the door and tell the bailiff that you're ready to leave.
Say what?
Just knock on the door and tell a bailiff that you're ready.
Have I pled true to the Class B trespassing already?
Not Mr. Pressler, the trespass was part of a motion to revoke your probation.
Oh, so see, today I was arraigned on a Class B trespassing offense.
Oh, that must be something else. I don't know about that, Mr. Pressler. Only thing I know is the 3 cases that we have here, and the first case is a criminal trespass, Class B, that you go on probation for. You pled true to allegations 2, 3, and 7, and that's cause number 325272. The second case,
we must have already done that. That was the last case then.
yeah. So the other case was cause number 327.
So we took care of 3 cause numbers already.
We took care of 3, but you withdrawing your plea on 1.
On the 4th one.
On the 3rd one.
No, you only had 3 charges, Mr. Pressler.
Which were 2 NTRPs and a Class A?
That's it.
Yes.
I was arraigned and appointed a $500 bail today.
Yeah, that was on your MTRP for your trespassing. And you pled,
I had to be arraigned on it?
Yes.
yes.
Okay, I understand. Thank you.
Okay. All right. Tell the bailiff that you're ready.